Hi guys, let's discuss what is a pure default judgment or pure default in relation to family law and how to get it done. So first of all, let's say you're the petitioner, you file for petition. You have usually two forms, FL100, FL110, and then depending on the county, sometimes ADR form 11.17. So you have these forms that someone other than you, over 18, serves the other side. There are two forms of service, either personal service or if the other side is willing to sign an acknowledgement of receipt, FL117, then service by mail. So let's say you opt out for one of these types of service. If you have personal service, the other side doesn't need to sign anything. If you have a service by mail, the other side does need to sign FL117. Whenever they signed FL117, 30 days plus 1 day, if they didn't respond, if you didn't give them an extension, if they didn't file anything else, then you can file a default, a notice of a default, FL165, and then move on with the default. The default is going to be sabotaged if during the time the court considering default, the other side does file something, such as response, FL120. So the main thing is 30 days and 1 day is when you can file for default. What is default? The scope of default. The Civil Code of Section of Civil Procedure 580 says the complaint has to match the default. So basically, if you ask for some asset split, then you cannot ask for sanctions in a default. It has to match. And Supreme Court in 1980, Lippel case, Lippel case, stated that there are no exceptions. You cannot add anything else. No sanctions, nothing. It's just pure, has to be the same. Like Miro, whatever you ask in the petition. So what you do in the petition, you attach to the petition a simplified asset split statement, could be FL160, and then assign whatever you keep, whatever the other side keeps. And so the default, the argument the Supreme Court made is that it doesn't give the other side sufficient notice, because if you do have a petition, you give them a notice, but if you have a default, it gives them very little notice and the court enters a default. Default means without their participation, the court makes a decision. So, however, someone appealed and said because the default should be set aside because the other side didn't include the values of the property in the petition package. And the Supreme Court said, no, we don't need it. It's not required. Values and proposed assignment, proposals how to divide is not necessarily required. I would be careful with that. So I would still make sure that I assign who keeps what, so it's clear. And then the values, I would still estimate them because I would assume they're not going to change. The reason for that is so that some judges still might decide it needs to match exactly what Supreme Court said before. Another case that came 2 years before the Supreme Court case in 1988, Wells case, the other side appealed, who received the default, and said, you cannot enter a default against me because in the petition you checked off 8 reserve spousal support, but in the default you entered an amount of spousal support. And in Wells, the court said it's okay. I mean, it's a contradiction to the court before, but nobody challenged that particular scenario. So the word of caution would be because the Supreme Court decided after about the asset split, but not about spousal support because that was not an issue. I would still, if the spousal support, if you have income and expense declaration from the other side, or you can estimate what they're making somehow, I don't know if they're not participating, that's what default is for. But let's say if you have the amount that you want the court to award, make sure you amend the petition, reserve it to the other side, and include that the amount should be matching. So that way you avoid judges who might deny that request for default because of the CCP 580. And finally, what forms do we need to use for our POD default? There is a list of forms. If you go and look at the form FL182 is a judgment checklist. The first line item is going to be default without an agreement, no responses filed. And then you have a checklist of all the forms. You just go over them and file them. So it's FL185, 170, 180, 190, 115 if the other side has been personally served, and then 117, preliminary declaration of disclosures, FL141. So all of that, you gotta double check that I didn't miss anything, so that all the forms need to be checked off, and then you bring the package in 3 copies and 5 copies of the judgment FL180, and then submit it to the clerk with the return postage as well as envelope, or hire a process server to do it for you, so they know the process. Anyway, so that's pure default without an agreement.